Good morning, Mr. Howard.
Good morning. Good morning to the court. Emmanuel Howard for Anthony Garvin. The verdict on the first-degree murder case here was substantially swayed by the trial counsel's errors. At the trial counsel allowed 4 weeds to continue to grow in the plot of land containing Mr. Garvin's life. By that I'm referring to Nelson Aponte, otherwise known as Snake, Louis Moreno, otherwise known as Pumba, Omar Marrero, the jailhouse informer, Gabriel Plaziola, named Gusty, whose excited utterance came in through Mr. R. Reyes.
The testimony of all of those witnesses was admissible.
Was admissible? Oh, yes, but not counted. There were many, many instances where the trial counsel missed and didn't take the opportunity to counter all of those witnesses and also bring in, that's countering in cross-examination, and also to bring in other witnesses who would have out and out contradicted them and would have supplied.
These are witnesses to what happened on the porch?
No. These are witnesses. These witnesses I'm talking about were Callum Daniels, Wayne Charlton, Leroy Codrington, and Officer Ortiz on the question of consciousness of guilt, which was raised both by officers showing up at the place where he was, and they didn't find him and they detained somebody. But Callum Daniels and Wayne Charlton and Leroy Codrington could have told the jury about what Mr. Garvin did after the shooting, and after he got home. He called the police from Codrington's home. Codrington was on the list and wasn't called. Officer Ortiz wrote a report that wasn't brought in front of the jury on Garvin's calls after shortly after the shooting incident when he went home. Wayne Charlton, who's Callum Daniels' stepfather, reports that when he came to Garvin came to the house, his house, he told them that he was robbed earlier that evening. So that was going.
Out of curiosity, how would that be admissible?
Well, it's in his state of mind to go. Consciousness of guilt is a state of mind. And
but you just said someone would testify that the defendant told him that he had just been robbed.
Yes, that goes to the state of mind, not for the truth and on my submission, because, as I said, consciousness of guilt, when you're arguing that and you're instructing the jury, that's a state of mind. And you say, well, he had a state of mind because he did this thing and the other thing and that, and he left town and didn't turn himself in, and 8 months he stayed away. And by that and other things, you can find guilt. Well, if you erase state of mind, which is a mental state, and Charlton can speak to that, in my opinion, that would do it. But Daniels can talk about what was observed by Garvin in Daniels' loft room. And Garvin, if he testified, could have contradicted all of the witnesses in various ways, as I described in my brief and in my moving papers down in the lower court. Now, what happened was that Garvin didn't testify because trial counsel set the case up so that he couldn't testify. He didn't talk to Garvin about what his defense was going to be, as is required under the CPCS standards of trial counsel for court-appointed trial counsel. And then he insulated himself. Trial counsel said at the motion for trial...
Well, you're not suggesting the lawyer never talked to Mr. Garvin.
No.
Because I think the record is clear that he did interview him prior to the trial. You're saying he didn't spend enough time with...
No. He spent the wrong... It's not a question of enough time.
All right.
It's what he did to set it up. Trial counsel had a predisposition. He had a bias.
You're saying the bias was he didn't think he did a good job on direct examination.
His bias, he said, I'm not good at putting my clients on the stand. If my client insists and bends my arm, a slight exaggeration, I'll bring in some other counsel to do this.
But didn't he also have an ethical consideration, not wanting to engage in suborning perjury?
Absolutely, and he should have withdrawn, because he knew that before trial, and the mass rules of professional conduct say that if he does know that fact before trial, he's to take steps to get himself out of the way and let other counsel come in and take over the case.
Did the attorney, though, get the second, and I really don't know this, did Mr. Schubert get the other attorney in to get sort of a second opinion on the defendant's defense?
No, not an opinion. Not an opinion. He didn't, I'm going to use the word insulate.
He being Schubert.
He being Schubert did not tell Linda Thompson what his concerns, ethical concerns were. I'm putting that in quotation marks. He let her, if that was carried through, be an unwitting and non-knowing source of getting perjury before the jury.
Okay, I'm not saying I disagree with you, but I'm just saying that it's not totally clear to me, since he didn't tell her, since Schubert didn't tell Thompson anything in advance, it's not clear to me that he wasn't sending her in just fresh so she could get a second opinion. Maybe he thought he was biased against whatever the defendant was now suggesting, and he just wanted a clean, clear second opinion. We don't know what would have happened after that.
That's not what he testified to at the motion for a new hearing, though.
I'm sorry?
That is not what Schubert testified to at the motion for a new trial.
What are you referring to? I'm sorry.
Schubert said the reason why I got her was because I was concerned that the defendant was going to perjure himself. I wanted no part of that, and so I didn't tell her, insulated himself, as it were. It's not as if we don't know what his tactic was. He's told us what his tactic was.
I didn't say, yes, he certainly did. And I'm saying that he should have withdrawn before. Linda Thompson shouldn't have been in the case. He knew
No, I understand that.
pre-trial, and he said, I knew that, I'm paraphrasing, he knew that he'd be limited, he meaning Schubert, would be limited in what he could ask Mr. Garvin, and that amounts to a conflict because, this is pre-trial, and he didn't get out of the way.
No, I understand
and that's why I say here's the other thing, to answer another question. He brought in Linda Thompson over the long weekend after he had already started the so-called defense case. He called two witnesses on the Friday before the long weekend. Before that, he told the judge, my case is going to be, I'm paraphrasing again, the judge wanted to know, how long will you be, Mr. Schubert? Well, about 2.5 hours. Well, he had 4 witnesses lined up. And with those 4 witnesses, and if he really believed that there was even a shot, and I'm using that in a short-term sense, of having the client testify as he avers, that wouldn't have taken 2.5 hours. And the judge motion judge was very charitable about that and said, brushed it off when I argued this and said, well, you know, I take that with a grain of salt. But that's not the way to look at it. It's what's in Mr. Schubert's mind, what his state of mind and what his reasons were.
Well, let me ask you about this conflict problem. If let's say he did withdraw from the case and Linda Thompson was assigned to represent the defendant. The defendant tells Linda Thompson he's going to get up on the witness stand and perjure himself. Linda Thompson has to withdraw, right?
But that's not what he said. He said he didn't say that the client. He didn't say that my client told me that he was going to perjure himself.
Oh, okay. So Linda Thompson forms the opinion that the defendant is going to perjure himself. Same position as Schubert, okay? Then her obligation is to resign, right?
Before the trial?
Oh, yeah.
Yes.
Okay. So 300 defense lawyers later and 50 years later, where the same scenario keeps on running through itself. Why isn't what the defense lawyer here did perfectly appropriate?
Judge, because the mass rules of professional conduct say that he should withdraw and let the chips fall where they may, because I think, excuse me for saying this, but this is an exaggeration, 365. There are other lawyers who would then maybe do some other things. For example, if the lawyer felt in a certain way, he would land on very heavily all of these 4 weeds that I was talking about, without even putting Garvin on the stand, and would have used non-toxic herbicides to get rid of those 4 weeds. They were weak to start with. So he would at least done that, and that's another reason why the client wouldn't testify. The client, and then here's another thing. We mentioned, and this is a misunderstanding, I think. It's not that he was no good on direct. He was just didn't want to prepare and bond. He was no good at putting his client on the stand. That's what he said. So now, but he knows cross-examination. So if Linda Thompson reported to him as he claims, he was going to have Garvin's going to have trouble answering an experienced prosecutor's question on cross-examination. Okay, so this is your own client. You, at least you meaning that an experienced trial lawyer handling murder cases, would know cross-examination. So you should take it upon yourself to make sure that he couldn't answer the questions. What if he can? And finally, every trial, I don't know how many, I know there are several trial lawyers on bench here, ex-trial lawyers. You know that you can talk to your client about how to behave on the stand, how to answer questions, how to comport yourself, how to direct your answers, how to think before you speak, and then ask some simple questions. What would you say if you were asked this? What would you say if you were asked that? What would you say if you were asked that? And that's the way you prepare somebody for cross-examination. Now, as a matter of fact, at the motion for new trial, Mr. Garvin stood up very well in cross-examination against that very same experienced prosecutor. And I'm not belittling the prosecutor, but I'm just saying that he did stand up. But to address another question, when trial counsel brought in Linda Thompson, she shows up in court On the very last day, over a long weekend, the defense counsel puts on two witnesses, Donald Jamison and Mr. Jakimowicz, the firearms expert, which he really didn't need. Defense counsel lost an opportunity on Jamison because he was the court officer who observed some activity in the lockup between Mr. Garvin and Snake, and trial counsel didn't get to Jamison soon enough, so Jamison's memory on the stand was not as acute as it would have been if he were interviewed several months earlier during the summer. So then, but Mrs. Linda Thompson doesn't know this. He brings her in, she sits in, this is the first time the jury sees her, without knowing Mr. Garvin, without her hearing trial counsel's representations to the jury, to the judge about his first defense, without hearing his opening when he shrinks down that defense and doesn't even tie in a motive that the Snake killed Poopy because of a coup d'etat, and he doesn't know who actually testified. She doesn't know who actually testified, how things went down, and I'm using that in quotes, at trial. She didn't know the potential but unused sources of evidence negating consciousness of guilt, about which I spoke, from Daniels and Charlton and Codrington and Officer Ortiz. She didn't know the potential evidence that would desiccate the weeds, that is, inconsistencies between Snake and Pumbaa's initial statements to the police. Neither one mentioned the other as being on the porch at the time of the shooting, and but they mentioned seeing each other on the witness stand. She didn't know that Gusty's initial statement to the police didn't mention him seeing Reyes Mr. Reyes, after he went out of the after Gusty went out of the house after the shooting, and Reyes said, "Well, I saw him," and in an excited utterance, he said, "The black guy just shot Poopy." So that also Linda Thompson didn't know about. She didn't know about the other contradictions, and especially here when Marrero lied 6 times on the witness stand about seeing a police officer after he made his initial statement to the police. She didn't know about Mr. Zanetti, Mr. Ramos, and Mr. Torres. Their statements were private statements that were obtained either by Mr. Garvin or by the investigator, Mr. Cocaros, given to trial counsel, was in trial counsel's files, which would have contradicted Marrero and given a motivation for Marrero to lie. That's all in the record. She didn't know about Pumbaa's recantation statement that he gave to, wrote out, witnessed by Mr. Cocaros, and given to Mr. Schubert. She didn't know about Presley Williams, who observed Marrero, Pumbaa, and Snake violating the sequestration order of the court. They talked about the case, and he didn't. All these witnesses weren't put on the stand. All this evidence wasn't put on the stand, and Linda Thompson didn't know about. So if you say of evaluation, you're bringing in somebody, and she sat there, no bad aspersions to her. She sat there during the presentation of 2 so-called defense witnesses, and that's it. She didn't address the jury. She came up at the sidebar once, and that's it. And Garvin knows all of these things, and in the charade, continuing the charade, because my contention is that that trial counsel knew right on Friday that Garvin wasn't going to testify because he set the case up so that he wouldn't testify. So he brings Linda Thompson over to the Hampden County Jail to introduce Thompson and Mr. Garvin. You know, who is she? Yeah, I heard about her, and so forth and so on. And incidentally, Mr. Garvin, you will see, did not.
Mr. Howard, could you try to wrap this up? You're over your time, and I mean briefly.
The trial judge, who was the motion judge, didn't allow the defendant to explore the reasonableness, the bias, and the credibility of trial counsel in the motion for new trial. And that, again, was damaging post-trial. And in conclusion, I would say that the errors combined likely influenced the jury, and we seek relief under 278-33E. Thanks for your attention.
Thank you, Mr. Howard. Good morning, Ms. Montori.
Good morning. May it please the court, I'm Jane Montori, an assistant district attorney from Hampden County representing the Commonwealth.
Could you please address the first question, whether, what your argument is as to why the attorney should not have withdrawn?
Well, I think on its face, the procedure here is troubling, and the motion judge commented on that. But I think then you have what has already been pointed out, this problem continuing in perpetuity. And I think that the solution here, which was to have another attorney handle the direct examination of this defendant, was the solution to the problem.
Why
in
isn't
this
that a
case.
violation of our ethical rules? Because he's permitting his client to get up on the stand and, in his opinion, perjure himself.
Well,
He's just doing it by a conduit.
I agree that you can't insulate yourself or another attorney from perjury, but in this case, it's on the record of the evidentiary hearing that, in fact, Attorney Schubert didn't know what the defendant would testify to.
Well, if that's the case, then why did he get Thompson in?
Because the main reason is because he felt that he was not very capable at doing the direct examinations of his clients.
I understand, but, you know, then
He
he
said
should...
this was his regular practice.
Yeah, but then he should withdraw. He's not allowed to say, well, I don't know how to introduce evidence. I mean, then he should, we asked CPCS to certify only the most skilled attorneys. The notion that you can't conduct a direct examination is ridiculous. I mean, it's like, maybe you say I'm not so good at cross-examination, which is much harder to do, but it's sort of trial practice 101, class 1, section 1. It's the easiest thing in the world to do.
Hadn't he been a lawyer for 34 years?
Yes.
And hadn't he participated in 60 murder trials?
That's what is on the
And
record,
he's saying
yes.
he didn't know how to do direct?
He just said he felt he wasn't very good at it.
Wasn't
And it-
that just code for saying, I'm not very good at it when my client's about to lie? And I mean, they don't
Well,
want
he
to
said
do
he
it.
did it in all cases, or most cases, that he didn't handle the direct examination of his own clients.
And so he calls somebody in the middle of the trial who doesn't know.
She wasn't called in the middle of trial.
No,
was she?
her name was announced to the jury.
At the time of
She
past
was
election.
given at least the police reports, if not all of the discovery. And I think what's significant here is that on the record at the trial, on the beginning of the day of trial when Attorney Thompson appeared, the defendant engaged in a brief conversation with the trial judge where the trial judge said, is this acceptable to you? And the defendant clearly and unequivocally said yes.
Is what acceptable?
The fact that Ms. Thompson would be handling his direct examination if, in fact, he testified.
Now, isn't this the case where the attorney testified that his client was not too smart? I mean, how can you expect a defendant to make a judgment about who should be questioning him? And
I don't remember that being in the
I
record.
think I recall that Attorney Schubert testified that his client, one reason he didn't want his client to testify was because he was not too smart, and we got tripped up on cross-examination. I mean, how can the defendant make a strategic judgment about who should be questioning him?
Well, he had already met with Attorney Thompson at the jail prior to that. Although Attorney Thompson didn't testify at the evidentiary hearing, she had reported to Attorney Schubert that she had engaged in role-playing with the defendant and that he did not stand up well on cross-examination. And I think the record of the evidentiary hearing of the motion for new trial shows that he did not stand up well on cross-examination.
This seems like a difficult question. Do you have a solution to it, a proposed solution? I can't think of one.
Other than what happened here, I can't, unless, I think it depends. If the client, if you know, based on the Mitchell standard, if the client is going to get up on the stand and perjure himself, and you know this before trial, then you have to withdraw. If you don't know what your client's going to testify to, which is the case here, I think this is the solution. Because I think the perception of when the jury, the perception to the jury of a defendant on the stand, you know, being asked an open-ended question and, you know, reciting his version of facts, and it's so different from any examination that has been conducted so far in the trial, I think probably impacts the jury to some extent.
Ms. Montori,
And there's some pall cast over it.
sure. We have a very experienced defense attorney here. Is it possible that the defense attorney knows that if he doesn't give some, at least vaguely plausible reason as to why he doesn't want to cross-examine the defendant, and you know, he says, look, Judge, it's not personal to this defendant. I haven't done it a number of times. I just find that it's not my strength, and I'm getting the best case for my client before the jury. I like to rely on people who are really skilled at that particular thing. I focus on the cross-examination, and I don't have to, you know, that's not a bad strategy to make clear that he's not suggesting to the prosecutor, to the judge, to anybody else that he thinks his client is about to lie. Right?
Right.
What else is he going to say? Because while he's having these little colloquies with the judge, the prosecutor's right there. So if he gets up and says, well, Judge, you know, I think the client is about to lie, and I just don't want, I mean, that's a terrible thing to do to his client, right? So what he does is he has a perfectly, on the face of it, plausible thing. I'm focusing here, and I'm going to let somebody else focus there. You know, it's like you take the expert witnesses, and I'll take the police witnesses.
Which happens frequently.
Sure. And he just says, I'm not going to do that. Somebody else can focus just on that, prepping him, working him, going through the questions. I don't want to, you know, that's not my focus.
And I think that's what happened here, but there was the additional element of the possibility of perjured testimony
May I ask you,
as another reason.
was there any testimony as to how often Mr. Schubert brought in outside counsel or different counsel for direct? If he did 60 murder cases, I'm just curious if we know if he did that in all 60 cases or if he only did it in those cases like this.
I believe he said it was his common practice, so I don't think it was limited to cases like this at all. And I think the evidentiary hearing transcript bears that out.
Yeah. And I'm just looking at Mr. Schubert's testimony. I mean, Justice Cowan was asking whether it was for a fresh look. Schubert is saying, I believe that there are certain questions he would not have been able to answer, but the most important point is it would have effectively destroyed the defense as I saw it. So in a way, he's saying to Thompson, I'm going to tell you what the defense is. I've got to cross-examine these witnesses. You know, if he insists on testifying, he has a right to testify.
And he said that on the record. And the defendant agreed.
Yeah.
The last question that was put to the defendant on cross-examination was, but you knew that you had a right to testify, and the defendant said yes. But he made the decision after consultation with Attorney Schubert and Attorney Thompson for the 29-minute recess on the last day of testimony, as well as the time that Attorney Thompson spent with him at the jail. And in fact, he was well advised not to testify. Attorney Schubert effectively cross-examined the two percipient witnesses of the Commonwealth, Aponte and Blanco Moreno, who I will refer to as Pumbaa. They both had pending charges at the time of the trial, and Attorney Schubert elicited testimony from them that in order for them to get consideration, they had to testify in conformity with their statements that they gave to the police on the night of the murder. And that was extremely effective cross-examination. In other words, they could not stray from those statements where they identified the defendant as a shooter, and if they did, they would get absolutely no consideration from the Commonwealth. In fact, Pumbaa said he would not have testified at all if he had not been promised some sort of a deal. It was a consideration from the Commonwealth. And
What do you say to Mr. Howard's initial comments about the four weeds that should have been addressed by Mr. Schubert?
well, I think those were two of them. Moreno, who was the jailhouse rat, was effectively impeached. The only thing he added was, he was not a witness to the crime, he added the motive, which was, it was some sort of a drug turf dispute. But first of all, he would not speak to the Commonwealth unless he was moved from the Hampden County House of Correction to another facility. He had snitched on another person that was adduced by Attorney Schubert. He was impeached thoroughly.
So
And
that's the third weed.
And the other person was the excited utterance. Gusti, who could not be found at the time of trial, but who was on the porch when the victim was shot. In the Commonwealth's case, the testimony from the landlord was that when Gusti ran by him after the shooting, he exclaimed, "The black guy just shot Poopy." When Attorney Schubert cross-examined Pumbaa, he elicited testimony that Pumbaa had been with Gusti from the time the shot was fired and when they fled the scene. And at no time did he see Mr. Reyes. So that effectively negated the excited utterance. And so I would suggest that Attorney Schubert's theory, which was put in through cross-examination of the Commonwealth's witnesses, particularly the two percipient witnesses, was a very reasonable trial strategy in this case, especially when it's viewed in the context of what the defendant might have testified to. First of all, when the defendant when Attorney Schubert first interviewed the defendant, and this came out at the evidentiary hearing, the defendant made clear that this was a drug dispute, and that, according to this version that Attorney Schubert was first given, he had no colorable claim of self-defense. Now, at the evidentiary hearing, he testified to a different version, that really absolved him of all responsibility for the shooting. But he could not explain why he never sought any kind of assistance for the victim. He never called the police to tell them that he was a witness and knew what happened. Instead, he hid from the police. He called the police, but when they stayed on the phone too long, he hung up, and he testified at the hearing that he did that because he didn't want to give them any kind of statement. He fled from the Commonwealth for 8 months. When he went home, he changed his clothes. He went from neighbor to neighbor. He saw the police apprehend the wrong individual. At that point, he didn't go down and tell them, hey, I just witnessed this murder, and I want to tell you what happened. It was an accident. Instead, he continued to hide and eventually fled. And that was what would have hurt him at trial, in addition to the fact that because he was the only one who would have presented this accident or self-defense version of the crime. The ballistics evidence, the medical examiner, and the physical evidence found at the scene corroborated the two percipient witnesses who saw the defendant shoot the victim in the back of the head as he leaned over a porch railing. And Attorney Schubert admitted that he advised the defendant not to testify, and that was good advice. And apparently Attorney Thompson gave him the same advice because he could not answer certain questions on cross-examination, including why he was at this porch on that particular day. So the question is, did he make the decision not to testify knowingly, voluntarily, and intelligently? And I think the motion judge found, based on the testimony at the hearing, that he did, and that it was a reasonable decision to rely on the defense that was presented at trial. And there was a conflict in the testimony. Attorney Schubert said the defendant knew prior to the trial what the defense would be. The defendant said he did not. I would suggest that the motion judge credited Attorney Schubert's testimony on that score. And as to the conscious not presenting additional evidence from the neighbors on who were present when the defendant was avoiding the police, I would suggest that would be more than reasonable not to call those witnesses to highlight that. And none of the defendant's statements would come in because they're hearsay of a party. So it would just highlight the fact that the defendant went to one house, called the police and hung up, and he fled to another house. He saw the police. He avoided them. He admitted at the evidentiary hearing that he was trying to avoid arrest, which defies common sense if his version of the events was to be believed. And if the court has no further questions, I would ask that the conviction be affirmed, the denial of the motion for new trial be affirmed, and that the court not exercise its power under 7833E.
Thank you, Ms. Montori.
Thank you.
Pardon me? Yes, ma'am.